Ladies and gentlemen, welcome to the Lord Renton Lecture, the signature event of the Statute Law Society. It gives me enormous pleasure to introduce our lecturer tonight, Lady Mary Arden. Lady Arden has been a Justice of the Supreme Court since October 2018. From 2000 to 2018, she was a judge of the Court of Appeal. She chaired the Judges' Council Working Party on constitutional reform between 2004 and 2006, and was head of the international relations team from 2005 to 2018. Lady Arden was called to the bar in 1971, which on my calculations means she was called just after she left primary school. She took silk in 1986, which is what is called at the bar scary quick. She was the first woman judge assigned to sit in the Chancery Division. Mary is also a member of the Permanent Court of Arbitration in The Hague, and just in case she has a single minute to call her own, she is also an ad hoc judge of the European Court of Human Rights in Strasbourg. We are fortunate indeed to have so eminent a speaker, and we look forward to a judge's view on what makes good statute law. Lady Arden.
Well, thank you very much indeed for that kind introduction. I'm delighted to be here, and I'd also like to welcome everybody who's come and everybody who's online whom I can't see, but much appreciate your listening. So it is an honor to be invited to give this lecture. I was somewhat surprised to receive the information, as I had given this lecture almost at the start of my High Court career, when I went to the Law Commission. The Society has a tradition whereby it very generously always invites the new chair of the Law Commission to speak about statute law. I suspect it's also to make sure they're on the right course. Anyway, here we are. I received a second invitation, and as I am due to retire early in 2022, I thought it would be nice to bookend my career by giving another lecture here. So thank you for this opportunity. Lord Renton himself was still very much in evidence when I started on the bench and when I gave my other Renton lecture. He chaired and he gave his name to a report of a committee on the preparation of legislation. It was immensely influential and led to major improvements in the accessibility of statute law. His report was a game changer. It was the first examination for a century of the subject. It offered 121 recommendations for the improvement of legislative drafting and was generally critical of the tendency of all governments to rush through too much weighty legislation through Parliament in too short of a time. So the recommendations were many, and they were clear that as a result, statutes have become clearer for the benefit of users. But although it was a report was welcomed by the Labour government at the time and welcomed by all political parties, I think I'm right in saying that it was never more than partially implemented. Lord Renton himself regarded the most important ones as number 13 on the statements of principle and number 15 of the statements of purpose. Recommendation 13 said that the use of statements of principle should be encouraged. Where detailed guidance is called for, in addition, it should be given in schedules. And then recommendation 15 said statements of purpose should be used when they are the most convenient method of clarifying the scope and effect of legislation, and also when so used, they should be contained in clauses and not in the preamble to the Act. So Lord Renton was extremely experienced in statute law and was profoundly interested in it. And indeed, I think he regarded himself as the custodian of it. He always put down questions for the House and the House of Lords. He was lively, full of energy, and full of conversation. So that's what statute law does for you. It did not matter to my mind that the report was not implemented in full. There had not been a report on this topic for some considerable time, and it raised the profile of a subject which many people care not to mention. I saw him at several lectures over the years, and my last mental picture, I thought I'd like to share it with you, of him was after an excellent Statute Law Society dinner in Lincoln's Inn Old Hall. He put on his hat and his scarf, marched off, lively, of course, without a stick, and went to his car to drive himself home. Nothing wrong in that, of course, except that he was 90 years old. Going back to the invitation of your chairman, I had not realized, of course, that I would ever be asked to do this lecture again. So it's something of profound interest to me because, like Lord Renton, I feel passionately about good statute law, and I'm keen to convey some personal impression of what legislation seems to me to help me as a judge, which was intended to have in the courts, of course. I just want to make sure that you realize the title of this lecture is A Judge's View, because of course, not everybody has the same point of view. Indeed, as one wit said, quod judices, sorry, this is in Latin, quod judices tot sententiae, as many judges, as many opinions. That can be true of the right approach to interpret a piece of statute law which is controversial. Now, as the chair has indicated, I just want to retrace a few steps. There are three significant steps in my learning about statutory drafting. First, there was a period at the Law Commission. Second, there was a period on the Company Law Review. And third, I was chair of the Judges Working Party on Constitutional Reform. And that included the Constitutional Reform Act and the discipline regulations for judges. There've never been any discipline regulations for judges, but I won't be able to deal with that this evening. But when it comes to legislation, the Law Commission had, as they say, it was a formative experience for me. And I went to the Law Commission and was privileged to be its chair for just over 3 years. I'd only been about 3 or 4 years on the bench myself. The Law Commission was the first opportunity I had for real immersion into statute law. I had no inkling during my university career that statute law was anywhere near as important as it is in real life. I certainly never understood how a statute was really made, or was I given any special learning on how to interpret legislation. When I realized how important it was, I began a little campaign for legislative history to be taught in universities, and it is taught in American universities, and I'm glad to say it's taught at least in short measure by universities here in the UK. So that's a very good investment by those universities for future lawyers who are skilled in statute law and interested in it. So the job of the Law Commission is twofold. It's to produce recommendations for the reform of the law and also reports on statute law revision. The former, needless to say, got much more attention than the latter, because the latter did involve some very expert work by devoted subjects poring over the statute book for redundant legislation. So it was really the work of the Law Commission with which I was concerned was the law reform work. And of course, as chair, you have to take prior law reform reports, which have been signed off, and try and pressurize departments into enacting them. Law reform reports from the Law Commission do eventually get implemented as to about 70%, but they don't seem to get implemented straight away. You often have to go and press for them to be presented as bills to Parliament. So they have to sit on the shelf for many years, and the chairman has to go around seeing members of civil servants in the departments and also members of both houses to try and persuade them that this is a project well worth endorsing. Law Commission reports are, to my mind, very special because they generally contain a draft bill to give effect to the recommendations. And this, at least in my time, meant that the Parliamentary Counsel's office was generous enough usually to post one of their counsel at the Law Commission to provide bills for their reports, for our reports. They were very much respected for their contribution at the Law Commission, and their work enabled the Law Commission to achieve acceptance of its reports within government and parliament at a far higher rate than it could ever have done. When I say respected, I mean both personally and professionally. You would send draft recommendations down to the Parliamentary Council and then wait to receive the draft. In my case, I worked on the second floor with my clerk from the law courts, and the other commissioners were on the same floor, and also the lawyers. Parliamentary Council worked on the ground floor near the exit, and I don't know to this day whether that was a strategic decision on their part. So Law Commission reports are very carefully thought through and painstakingly put together. An important part of the process is issuing a consultation document with well-chosen questions and receiving the responses and digesting them. The Law Commission consults very widely, which means you can have a very wide range of response, from large companies to individuals. But what interested me was this: however hard you worked on those recommendations and getting the detail of your consultation document right, there was nearly always a letter from yours truly, Tunbridge Wells, which exposed some point which had not occurred to any of us. I remember Professor Burrows, now Lord Burrows, and a member of the Supreme Court, poring over his report on third-party rights in contract one evening. He had a mound of papers around him and books open. When I asked him what he was doing, said he was dealing with the 200 points that Professor Tritle had sent him. When we sent what we thought were our worked through and comprehensive and intelligible and consulted upon recommendations to Parliamentary Council, we expected to see something that approximated to what we had written. But we were often disappointed in that when the bill came back, brought to me by my clerk on a notional silver salver, such was the respect. I puzzled and wondered why this particular language has chosen. But this was my chance to learn one of the most important things that I learned, which is that the quality of the bill, it reflects almost directly on the quality of the policy behind the recommendations. In other walks of life, not statute law, one might say rubbish in and rubbish out. So that was really important lesson to me, that you had to work out the policy in great detail to be able to answer all those questions, and then Parliamentary Council could do an outstanding job using the sort of language that would have to be used in a statute. So that really takes me on, if I may briefly, to the Company Law Review, because shortly before I left the Law Commission, I became a member of the steering group of the Department of Trade and Industry's Company Law Review. This was set up in 1998, sounds like a very long time ago, to make recommendations for the reform of company law. It was, for me, the experience of a lifetime. I was, after all, a company practitioner at the bar. This review followed the tradition of company law reform, which was that it would be subject to a major review every 30 or 40 years because of its commercial importance. The previous reports had been done by some of the best company lawyers of their day, including Lord Justice Jenkins, Lord Green, Lord Cohen, and Lord Renbury. But perhaps they were more leisured days. Even by 1998, the field of company law was too large and too complex for a judge to take it on as an out-of-court responsibility. I was initially very disappointed that there had to be that break in tradition, and that the steering group was to be served by a senior civil servant. But I concluded before long that this was a stroke of genius. The civil servant involved was Richard Rogers. He was very senior and well accustomed to chairing meetings in the best tradition of chairpersons. So what I'm trying to say is that he never cut the debate short. He steered it, of course, but he did that merely to draw the views together. He never tried to influence us. Now, the members of this review were very broadly drawn. They included lawyers, accountants, businessmen, journalists, economists, and others. And we had a much talented and very senior secretary of the review, Jonathan Rickford. He knew the form in Whitehall. He ensured that the steering group was run like clockwork within the short period which it had been given. He also ensured that the steering group looked at all the relevant issues, consulted all the relevant people, procured research where necessary, and monitored all the consultation that had to be done, and then skillfully committed views to paper. The work of the Company Law Review took approximately 3 years, during which time it issued about 9 consultation documents on various aspects of company law. I recall to this day that members of the profession used to call these consultation documents green bricks on account of their size, because many of them were very substantial indeed. But the issue of these documents was important. It gave the interested bodies of the profession and interested companies and individuals, of which there really were very many, the opportunity to participate in the formulation of the law and to send in representations so that the recommendations which were ultimately made were evidence-based. Then the CLR produced its final report, pretty much within the set scheduled 3 years. Now, the approach, as I've mentioned, was a multidisciplinary approach. So that meant that the areas really were exposed to the scrutiny by business people and economists and many others. At the start of the review, the Company Law Review did something really rather interesting. It formulated a number of guiding principles that were going to guide its work. I'll give you an example or two just to show what they mean. There was the principle that companies are not, of course, formed only by British investors. The corporate vehicle of the British limited company is also used internationally. For company law has to be competitive, and to do that, it needs to produce fair and certain outcomes. Another objective was the emphasis on the importance of clarity, mitigation of the burden of costs and compliance, and awareness of the needs of users. It must be expressed in a form which promotes compliance and makes compliance easy. Otherwise, the law gives rise to significant cost, uncertainty, and risk. Now, this was a technique which the Company Law Review borrowed from the Law Commission. I'm glad to say that because I was the link between them too. But the big difference between the Law Commission and an ad hoc law reform committee, like the Company Law Review, is that the Law Commission has built up expertise in running law reform projects, whereas an ad hoc committee almost has to discover it for itself afresh. And so the Law Commission, which is much to be supported, has an institutional memory which is lacking so much elsewhere. In due course, the government largely accepted the recommendations of the Company Law Review and issued not just 1, but 2 consultation documents of its own. It issued summaries of responses in accordance with best practice. Finally, the bill was drafted, and the bill, as presented, merely made amendments to the Companies Act 1985, and it was called the Company Law Reform Bill. But Parliament decided that the bill should be a consolidation bill. So a record number of amendments were introduced at the report stage in Parliament. And it is said that it is the record number that has ever been produced at that stage. The name of the bill was changed to the Companies Bill. And so the bill, in due course, as amended, contained a consolidation of the entire Companies Acts. So it held 2 records, one for the record number of amendments produced at report stage, and secondly, for the sheer size of the bill and the enactment that followed. It is said it was the largest act ever passed by Parliament. And I would like to say this, and I hope you won't think she would say that anyway, but as a piece of legislation over the last 20 years, it has not been the subject of a huge amount of litigation. There is some going on, of course, but the basic act has fared very well among practitioners. And I like to think that was because of the measure of thought that went into it, the planning and the scrutiny by outsiders. And that, of course, is one of the points that I would wish to make about statute law. It's the statute law which has been prepared with this level of thoroughness, which is most helpful to the court. Constitutional reform, I just want to mention briefly, because you may wonder what it is. I was chair of the Judges Working Party on constitutional reform. This came about because Tony Blair, as Prime Minister, decided that the office of Lord Chancellor should be reformed. He would no longer be head of the judiciary. This was easier said than done, because over the course of many hundreds of years, literally hundreds of acts of parliament had been passed giving him powers in relation to the judiciary, mainly powers of appointment, but also rule-making powers. And since he was being removed as head of the judiciary, it was necessary to entrench in legislation several principles, such as judicial independence and the rule of law, because the Lord Chancellor would no longer be able to protect those principles, or at least not protect them as well as he had done in the past as a member, senior member of the cabinet. The legislation also produced the concept of an independent appointments commission to select candidates for judicial appointments, and it also gave the powers to introduce discipline for the judges, and of course it set up the Supreme Court. The then Master of the Rolls, Lord Wolfe, had arranged a master plan for this called the Concordat, which was agreed between government and the judiciary, which somehow had to be translated into watertight legislation. And my working party was engaged with much of that detail, and of course, with the Lord Chancellor's powers of appointment and rulemaking in relation to the judiciary. All those experiences brought me into very close contact with the process of making statute law. And apart from following those instructive experiences, I'm now at a stage in my career when I have sat for about 27 years, regularly having to look at statutes. And I have reflected on the object of legislative drafting and what is most helpful to the court. My view, having seen many statutes, is that the starting point and the end point, I'm not saying nothing about the middle, is always the words themselves. There is a school of thought that purposive interpretation does not require the same dedication to wording as literal interpretation did. Well, that may be true to some measure, but you still need to justify your interpretation by the natural meaning of the words. In my view, that is totally essential. You are giving effect to the words that Parliament has chosen to enact. It's your constitutional responsibility. So what you cannot do is stick a finger in the air and say that must have been the policy. When I first became a judge, one of the members of the House of Lords was Lord Gough of Cheveley, a very fine judge indeed, and he gave me some very sensible advice. He advised that I should avoid what he called, I think, jurisprudence. That is, jurisprudence which the judge says, I think the position must be this, but never references by reference to the case law or the statute, whichever he's dealing with. I thought that was very good advice. He recommended also that there should be a notice on everyone's desk which said, always test the assumptions. So also very good advice, and I'm very grateful to him. From my law reform experiences, I had learned that statutory interpretation is a very granular, dedicated and humbling exercise to give effect to a policy and not one's own conception of what the policy should be. And normally one found that the policy was very thorough indeed. If there was any trend to be found today which should be railed against, it is possibly a trend to impose purposive interpretation without the thorough interpretive exercise which I have mentioned. What the most eloquent supporters of sticking to the words, one of the most eloquent supporters of sticking to the words was Lord Hoffman, and I'd like to just quote what he said. What the interpretation of commercial documents and constitutions have in common is that in each case the court is concerned with the meaning of language which has been used. As Associate Justice Kentridge said in giving judgment in the South African Constitutional Court, if the language used by the lawgiver is ignored in favor of a general resort to values, the result is not interpretation, but divination. So the first lesson is stick to the words and not what you think might be the policy. So what else did the Law Commission teach me when I got back on the bench? As I say, the most important lesson was the importance of the thoroughness of the preparation of the policy. And that realization, it seems to me, has implications for judicial work. you start to realize that interpretation is not just reading words, but the process of getting into the concepts and the aims behind the provision. If you can find out more about that, then the view that you will arrive at is a more accurate, informed view about the interpretation of this statute. So what are judges doing when they interpret an Act of Parliament? Perhaps I should start here by mentioning that there are two schools of thought. On one school of thought, the judges are effectively deciding what the law should be. As one very eminent judge was reported to have said in argument in the Court of Appeal, the law is not what is written in the statute book, but what we hold it to mean. But the other way of looking at the function of judges, which I would prefer, is to regard their role as trying to find the proper meaning of which Parliament has expressed in the legislation, the proper meaning of those words. And to do this, judges have to be trained and experienced and temperamentally prepared for the intellectual hard work, the deliberation, and of course, the detachment. But as I say, that's part of our constitutional responsibility. So there are three particular techniques that I want to highlight this evening, and I think in appropriate circumstances, they really help judicial interpretation. The first, what I did was conveniently find three techniques that began with the letter P, so in the hopes that you might remember them more easily. The first was Prelegislative Materials. The second was Purposive Drafting. And the third item is Policy. Now, Prelegislative Materials. Now, to do what I have described judges ought to do to elucidate the meaning of a statement, the judge simply has to have access to a wide range of pre-legislative materials. I'm not including Hansard. I'm talking about the materials that led up to the legislation. Not all judges are very enthusiastic about this particular approach because it can be very difficult indeed to find the relevant material, and the process can be very time-consuming and detailed and may at the end of the day yield no answers that help. But for my part, I think it's important to try to look at all the admissible material, and counsel appearing before the courts have the primary responsibility for this, but they may not know how or where to find it. I do not suggest that when you look at the pre-legislative material, you will be looking for, or still less find, a silver bullet, which answers the precise point in issue. That's most unlikely. Its purpose, as I see it, is to contextualize the issues. And as some of my predecessors would have said, to help you learn about the mischief of a particular provision. At the end of the day, it's still what the words actually mean. So admissible material for this purpose includes consultation documents and reports about the proposed legislation. And also, I find useful documents which explain those documents. And also, if there are any, select committee reports and sometimes private law reform documents. But they have to really, in essence, I think they should be by public bodies and therefore official publications. But when you find you have obtained a consultation document and compare it with the legislation, there are usually a number of important disconnects. What you thought was being expressed in the consultation documents is not carried through to the ultimate bill and the legislation. And that is just one of the situations in which it is not simply enough to look at the consultation document. You actually also have to look at the summary of responses, which departments are obliged to file, to prepare, and in due course, I think they are usually presented to government. But they're very useful documents too, because they can help bridge that gap between the consultation document, maybe a white paper, and the legislation itself. And in the case of the Company Law Review, as I mentioned, there were 9 consultation documents and ultimately a final report. And so if you wanted to track something through those consultation documents, it is a very arduous task. Now, I mentioned that it can be difficult to find all the relevant material. That's personal experience for you. It's a feature of legislation that it's designed to stand for a very considerable period of time, and the materials may be very dusty. And the question you've got to decide may be something which was not there in the beginning, but has only just arisen. And so you may well find that the explanatory material may not help very much. But if, for instance, there are guiding principles, or at least objectives of the law reform, you may be able to take that away and then use that as the core of an idea for saying that the words should have a modernized meaning in a particular case. There will be other cases where pre-legislative materials really do give you the big picture and enable you to give a very informed view about what the statute is trying to do and has done by the words used. Sometimes people do an internet search or a database search, but you can often find that that is useless in trying to find the relevant materials. If they are official publications of the department, one would hope to find them on the departmental website, or if they're not there, on the National Archives. After all, the Cabinet Office requires departmental publications to be archived at the National Archives within a period of completing a project of work. But of course, not all departments will have the time or resources to do this. And so there will be an interval time when probably the documents have disappeared off the departmental website and are not available on the National Archives. This is a sad state of affairs, and it may be that the only possibility is a freedom of information request. For my own part, I find it very frustrating when council submit that before the legislation was drafted, there was a public consultation on various matters, if we are not also shown that document. But I see no good reason why in the appellate courts there is not enough time while the appeal is waiting to come on to research and find the appropriate documents. The courts do not work in complete isolation from Parliament. From time to time, their paths cross. And if I am right on the theory of interpretation, the aim of the judge should be to put himself as far as possible into the shoes of Parliament as to what it thought about the legislation when it enacted it. Now, I've been discussing pre-legislative materials of a certain kind. They are really rather different from the explanatory notes. Everyone knows that for every Act of Parliament, there is now a set of explanatory notes. Their function is to explain, and they may be published with the bill as well as after the Act is enacted. It is now clear that they are admissible in a court of law on interpretation. They are freely available on Parliament's websites. It was originally intended that these would set out the concepts used in the legislation, but I thought I might just explain how they came about. When I arrived at the Law Commission in 1996, I had a number of discussions with counsel assigned to the Law Commission, Geoffrey Bowman, later Sir Geoffrey Bowman, head of the Parliamentary Counsel's Office. I explained I would like to do a project on statutory interpretation. I found soon that first Parliamentary Counsel, Sir Christopher Jenkins, was interested in talking to me. And he had well-developed views about what the Law Commission should do in relation to statute law. And he also had very well-developed views about the best way to access the meaning of legislation. Unlike many others, he took the view that it was not helpful if legislation included any explanatory material itself. In his view, the function of legislation was to change the law and to be operative. And indeed, that is what Lord Lisvane said when he addressed the Society recently. So after many discussions with Parliamentary Counsel, I was persuaded there wasn't much point in doing this project on statutory interpretation. Instead, the right course was for Parliamentary Counsel to try and devise a method of giving explanatory material outside the legislation. And this they did by the explanatory notes, which we now have, as I say, for every Act of Parliament. They were introduced gradually from about 1997. Geoffrey Bowman's concern was that the notes might actually conflict with what the Act said, and so he would have preferred a rule which prevented them from ever being used and ever being admissible in the courts for that purpose. But he bowed to the inevitable, so that they could be used by the courts, because of course that was a question for the courts, not for the question not for the decision by Parliamentary Counsel. So that history is a contributing factor to why we have explanatory notes today. But because of pressures, it seems to me that it's quite rare to find explanatory notes these days which are really helpful on an issue of statutory interpretation. The sort of question one gets to interpret legislation in the appellate courts is one which is very granular indeed, and it's because nobody has been able to solve it. And the explanatory notes do not descend to that level of details. So if I had to give them stars, it would probably be 3 stars, not 5. And as I say, usually they're not very helpful because they're too general, but they can only deal, and this is the second problem, only with problems that were known or foreseen about at the time. So I'd like to give a big plug for pre-legislative material when you want to interpret a statute. My second concept, beginning with the letter P, was purposive drafting. Now, I do not mean purposive interpretation, because we all know what that is. I mean material in legislation which sets out its purpose as the policymakers and Parliamentary Counsel saw it to be. It can be very successful indeed. Section 1 of the Arbitration Act is the prime example of this, because it says that the provisions of the Act are founded on the following principles and shall be construed accordingly. A, the object of arbitration is to obtain a fair resolution of disputes by an impartial tribunal without unnecessary delay or expense. B, the parties should be free to agree how their disputes are to be resolved. And C, in matters governed by this part, the court should not intervene except as provided by this part. So that was very clearly put indeed, and has proved to be immensely helpful in interpreting the powers given by the Arbitration Act 1996. But as you heard when I read out the recommendations of the Renton Committee, which Lord Renton was particularly proud of, purposive drafting cannot be universally appropriate. The real risk is the risk that Geoffrey Bowman noted. If the statement of purpose has legal effect, it may conflict with the provisions in the Act which follow the statement of principle and lead courts to think that there is no conflict and that the provision should be interpreted down or up, as the case may be, to match the statement of purpose. Another problem with purposive drafting, and this is one I think I most experience, is that it probably turns out to be much too narrow as the legislation has developed in its use over the fullness of time. It may just not deal with the sort of problems that have arisen. It may also mix up operative provisions with explanatory material, so that the legislation may have a different effect from that which was intended. And on occasions, there will be, it may be that that is the appropriate course. I want to say a word here about simplicity, because as you listen to that provision from the Arbitration Act, I'm sure you were struck by its sheer simplicity. The best statutes are those which have been framed on the basis of simplicity, lucidity, brevity, and the avoidance of ambiguous terms and superfluous language. There is then no need for purposive drafting. And in this context, I would put in a play for some more structured discretions. One would have thought that Parliament would often like to tie judges down when it comes to the exercise for statutory discretion, but in practice, they do not always do so, or if they do so, it's on an incomplete basis. Structured discretions tell the judges what criteria to take into account, and they may or may not exclude other criteria. They are, in my experience, useful, particularly because it enables the courts to give decisions which across the board are consistent. That avoids unnecessary appeals. So if in the right place, if Parliament knows what criteria should be applied, to the exercise of a discretion, I respectfully suggest that it would be useful if they said so. It is always difficult for parties to appeal a question of discretion unless it's on a point of law. And it's difficult for the courts to limit the broad exercise of a discretion if there is no error of law. I'd also like to put in a point at this stage about schedules. Schedules to an act, of course, something that everybody comes across. And we came across it most recently in a case called Morn and the Oxfordshire coroner. This was a case where sadly, Mr. Morn had died by suicide in prison, and there had to be an inquest. And the question at issue was, what was the burden of proof that had to be established and that the jury had to be satisfied about before they could pronounce a verdict, if they wished to do so, that it was suicide. And in this case, the evidence was sufficient in the coroner's thinking to satisfy the burden of proof on a balance of probabilities, but not if it was against, if it was on the criminal burden, that there had to be no reasonable doubt. So the question arose, which the courts had to consider, was what was the appropriate burden of proof for coroner's inquests dealing with people who died by suicide. And having studied the case law very thoroughly, the court concluded, as did the divisional court, that there was the weight of authority was against the criminal standard and in favor of the civil standard, because after all, the matter was not dealing with any criminality. So in the event, we looked at the rules which gave effect to the Act for holding coroner's inquests. And then somebody noticed that there was a schedule to the Act which contained a form, and the form contained notes. And the notes to the forms said that in the case of certain verdicts, which included suicide, the standard would be the criminal standard of proof. The standard of proof required for the short form conclusions of unlawful killing and suicide is the criminal standard of proof. For all other short form conclusions and a narrative statement, the standard of proof is a civil standard of proof. And so the issue was whether or not the courts could say that all Parliament was doing by that note in the schedule is set out the common law rule as it understood it to be, because many cases in the recent past had interpreted as criminal standard, wrongly we thought. Or was it actually stipulating that the standard of proof was now codified, no longer a matter for the common law? It was a statutory rule that it had to be on the criminal standard. There was a difference of view in the Supreme Court, but the view that it was descriptive only prevailed. And in giving the judgment of the court, I chanced, among other reasons, to refer to Lord Thring, whom, as some of you may know, was one of the founders of the modern practice of parliamentary drafting. And I cited him for the proposition that the schedule should be only used for matters which were relatively unimportant in the statute. And that formed part of the judgment. And so the court reached the conclusion that the note was descriptive only. What Lord Thring said was, great care should be taken in the preparation of schedules. It's desirable to include in a schedule matters of detail. It is improper to put in a schedule matters of principle. All that can be said is that nothing should be placed in a schedule to which the attention of Parliament should be particularly directed. For example, the constitution of an electoral or financial body. Now, this was a document which was headed Instructions for Drafters, and it seemed to me to make admirable good sense, particularly as the clause which led into the rule-making power, had simply said that coroners could use the form in Form 2. So when this decision was published, Mr. Diggory Bailey, one of the Parliamentary Counsel, wrote an article in Public Law. And his view was that the division of material between the body of a legislative instrument and any schedules is usually a matter of professional judgment for the drafter. No hard and fast rules. It's normally a question on how best to present the material to the reader. In the case of primary legislation, the decision to put material in schedules is also occasionally influenced by parliamentary handling reasons. And then he says, a schedule is always introduced by a proposition in the body of the legislation so that the readers know it is there and what it is about. Well, certainly the power to make the rule, give the form, was provided for in the body of the rules, but it certainly wasn't said that this form was about to codify a common law principle. And so I was, the upshot of this was that Lord Thring's book should no longer be taken as expressing current legislative practice. A more reliable indication of the current practice, said Mr. Bailey, would have been the discussion in the drafting guidance produced by the Office of Parliamentary Counsel. So there we are. It seems to me to make good sense that schedules are only used for purposes of giving detail, and that if they're not to be used for the purposes of giving detail, it should be clear on the face of the enacting instrument that they have some wider purpose. And I did study the manual, but I couldn't see anything to suggest that the principle which Lord Thring laid down does not still apply. If he wasn't right, we could, of course, have legislation in which, indeed, the schedule said, and the town clerk of Leeds is hereby divorced. Remember, that's the apocryphal story which is told about legislation. And I have another problem. How is one to know where parliamentary councils practice and drafting conventions are to be found, and who is in charge of their being issued as such? So I remain unrepentant about this approach to statutory drafting, but I thought you would be interested to hear about it. Let me finally deal with policy. It's not because I think that judges should be making a policy, you know that. There are only 3 points that I want to make here. The first is, sometimes legislation looks very curious to the reader many years later. But we have to remember that the promoters of the bill may well have had to compromise on what they wanted the bill to say and what the bill could actually achieve. And so it may be that the policy looks rather short-sighted or doesn't cover every case. Sometimes, this is my second point, sometimes you can work out the policy from the text, and then suddenly all the pieces of the jigsaw start to fall in together. And thirdly, as I've said, what a judge must not do is form his or her own view on the policy using his or her own value system. The only valid policy reason is the policy that can be deduced by reasoning from the actual provisions of the legislation. And I thought, because this was such an important point, I would give you one example, but not taking it from current cases that you will have seen recently, but one from about 1982 called Ex parte Shah. Now, in this case, Commonwealth students had been encouraged to come to the UK to study, and there was a possibility of getting a mandatory grant from the local authority. But to do that, you had to show you were ordinarily resident in the UK, ordinarily resident. And so these students who came from the Commonwealth only had visas for study, which meant they would have to return at the end of the period of study, from which it was said they are not ordinarily resident in the UK. So the matter went to the Court of Appeal, and the Court of Appeal said that the Commonwealth students were not entitled to mandatory grants. Lord Templeman added this: it is improbable that the Education Act 1962 was intended to entitle overseas students to a mandatory award. The Education Act effects a redistribution of revenue in favour of students and the parents of students. Parents ordinarily residing in this country will have contributed to that revenue in the past. Students, other than overseas students, can be expected to contribute to the United Kingdom revenue in the future. Parents of overseas students and overseas students themselves who leave the UK after they have completed their education rarely, if ever, make a contribution to the revenues of the United Kingdom at any time, and it is unlikely that the Education Act was intended to include them in the compulsory redistribution of revenue which was effected by this Act. There were strong words, but anyone who knew Lord Templeman knew that that was exactly the man. He was also in his day a very great tax lawyer, so he was keen on looking at matters from that point of view. Now, happily for the students, the House of Lords found that you can be ordinarily resident in more than one place, for the purposes of the law, that is. But Lord Scarman was expressly critical of what Lord Justice Templeman had said. He said, the way in which they used, that's the Court of Appeal, used policy was, in my judgment, an impermissible approach to the interpretation of statutory language. Judges may not interpret statutes in the light of their own views as to policy. They may, of course, adopt a purposive interpretation if they can find in the statute, read as a whole, or in the material to which they are permitted by law to refer to as aids to interpretation, an expression of Parliament's purpose or policy. But that is not this case. The Education Act's only guidance is the requirement contained in the regulations that to be eligible for a mandatory award, a student must have been ordinary resident in the UK for 3 years. There is no hint whatever of any restriction, provided, of course, that he has the educational requirements, qualifications, and his conduct is satisfactory. So that's Lord Scarman. And Lord Scarman in his time was chair of the Law Commission and knew a lot about statutes. So it is always back to the words. I think that brings me really to my conclusion. I will probably have to end where I started this evening, with that Latin tag, quod judices tot sententiae. Different judges have a different approach to statutory interpretation. And when they come to produce their result, you will often find that that is so. But hopefully they get to the same result and reach the same conclusion in a reasoned and principled way. And that is, of course, important for the discharge by their judges of their constitutional function in relation to statutory interpretation. It's a constitutional process to interpret the words of Parliament and make it the law of the land. The science does not stand still. And the common law, sometimes people say, is diminishing, but it's probably Macauberism. Statutory interpretation, on the other hand, and statutory techniques are a bit like the magical coat in fairy stories. It grows as the law grows, and it always fits, and it never wears out, just a matter of finding it out. Statute law has grown immensely in the last century, and with the help of this society in particular, I feel sure that statutory interpretation will keep pace with change. Thank you for listening to me.
We have a marvellous record of eminent speakers who are kind enough to speak to this society. All of them manage some link between the subject they choose and statute law. But few grab the subject and turn it inside out, quite as Lady Arden has done tonight. All of us, practitioners, students and judges, look at statutes on a weekly, perhaps daily basis. But seldom do we get an insight into what goes into the production of an Act of Parliament and what ought to come out of an Act of Parliament, quite as we have tonight. We have had the most expert of analyses into that process. Mary, thank you very much for a fascinating lecture. Ladies and gentlemen, Lady Arden has said she will take questions. We have some coming up online. It's one of the benefits of lockdown and COVID is that nowadays lectures like this always go out online as well as in person. And I know we've got over 300 people listening to this online. But I'll look around the room first of all. Any questions for anybody? Yes.
Lady Arden, in your section on pre-legislative materials, you referred to the explanatory notes which have been introduced since 1997, and which are public documents, so necessarily fairly bland. My memory is that there used to be much more comprehensive material, pre-statutory materials, in the form of notes on clauses, which weren't public documents, and they were kept in the Inland Revenue Solicitor's Office. Have notes on clauses disappeared? Were they, apart from the fact they weren't available as public documents, were they potentially superior to the explanatory notes which we now have?
Well, I'm perhaps not the best person to ask. You perhaps ought to ask a civil servant, and there may be one here. But my understanding is that notes and clauses are still around. They are the guidance for ministers when they're in Parliament with the bill. But your question is, are they potentially superior? I would have thought not, because of their very limited function, whereas explanatory notes are intended to help people on a wide basis. I tend to agree with you, as I explained, that they have become a bit bland, but that's pressure on resources and time. That's how they are now, but in the beginning, they were much more informative, in my view.
Can I put one of the questions from one of our online listeners? I'm sure if I knew how to work this, I could see who's delivered it, but I can't see that. So I'll just ask the question. Who should legislation be drafted for? And does or should identification of the audience for legislation influence the approach to interpretation?
Well, legislation must be drafted for the people who are going to be using it. And in general, that's a very wide section of the public. When one says that, of course, you mean somebody who's reasonably interested in the statute and who can cope with statutory language to a certain degree. Now, should it be differently interpreted for different groups of people? The answer, I think, is that what I'm suggesting is that it might be differently drafted for different groups of people, just as the Arbitration Act was done in different way to perhaps some other statutes, because it was intended to reach a very wide audience, many of whom would either be not using their mother tongue or who would be commercial people and therefore wanting to understand how the Act would work in practice. But I don't think that the courts will interpret legislation differently. On the other hand, I do want to stress that the audience to whom legislation is drafted is certainly a factor which the court will bear in mind.
Thank you. Another question from the room? Yes, gentleman there.
But doesn't the heavy reliance on pre-legislative material when interpreting the statute make life more difficult for those affected by the legislation who are reading it and trying to work out what it means?
Yes, that certainly must be the right answer. But then hopefully these documents will all be publicly available. I was hoping by mentioning this to encourage people who have the burdensome task of putting these documents into the National Archives, because then it's only just a click and you get that. Now, what I don't want to do is suggest that you need a lot of expensive legal advice. Hopefully, Counsel has done a really superb job, as in the Arbitration Act. But just from time to time, there is a point that comes up that needs to be elucidated. And I think it adds to the confidence of the process that when the judges look at the admissible pre-legislative materials. So they're not forming a view of their own or in isolation or in some ivory tower, but in reality, what was this intended to do?
Another question from in the room. In the meantime, can I ask if somebody could help me with this? I've obviously pushed the wrong button and I've lost all the questions from our online audience. If anybody can help me. Let's take another question in the meantime. I saw somebody. Yes.
Oh, I was just going to ask, firstly, thank you very much for the speech. But one of the things that you noticed was how much good scrutiny and consideration impacts the statute law. So I was just wondering, in relation to things like delegated legislation, statutory instruments and the like, where there isn't necessarily much time and ability to scrutinise things at high levels. In lieu of that, would you say there are any particular concerns and criteria that make a good statutory instrument, for example?
Well, that's a really difficult topic and a very different topic. And I think that Sir Jonathan Jones was here not long ago talking about delegated legislation. And there's no one better to do that, since he was the Treasury's solicitor and would be, therefore, the chief legal advisor to all the departments. But the process is entirely different. There isn't that exposure. There may be some exposure by way of a consultative draft, so that, for instance, there will be a draft statutory instrument and a period of time to respond about it. But the process is not a flexible one, as I understand it, within Parliament. You put your statutory instrument in, whether it's to be affirmative or negative resolution. You can only vote it in, you can't amend it. But there is one very good process, and that is the Delegated Legislation Committee will look at it. But it's not ideal.
Another question from online, since I've managed to get the machine to work again. It reads as follows. Lady Arden, you have been lecturing on legislation over a long period of time. Do you feel that legislative innovation is no longer a priority, perhaps set aside by Brexit and the pandemic? Legislative innovation.
That's right. Well, I think that the making of legislation is with us for a very long time indeed, and you have to modernize the approaches to anything over time. And also you have to make sure that that institutional memory is carried on by parliamentary drafters today, and that people learn about legislation. There are certainly innovations, and there are certainly new challenges. For instance, bilingual legislation is going to be a new challenge in the future. So we have to keep brushing up our skills and thinking how better to do it. We want to do a better job each time.
And we have one more question from online and one more from the room. The one online is this. Lady Arden, do drafters and judges speak the same language? Drafting seeks direct communication with legislative audiences, whereas judges seek the ordinary meaning of words. Do these pursuits meet?
Well, I'd like to challenge the assumptions, because that's what Lord Gough told me to do. Namely, judges aren't these days simply looking at the ordinary meaning of words. They are very definitely trying to embrace purposive interpretation. And that's not completely new. It's what's been done over many years, but it's much more present now. We notice it much more. My cri de coeur is that they do it by reference to the language and also inform themselves by the pre-legislative materials. And with respect, I hope that that will put judges into a better position to interpret legislation, because they know the context and they're more familiar with it.
Thank you. One more from the room. Lady there with the hat on.
Hello, thank you for the talk. I'm coming from Turkey. It's my just 5th month here, and I came here to live as a woman in a better way. And I'm a psychologist, but from the time that I've been here, I lived terrible things, and I experienced that actually in all over the world, not in Turkey. There is a huge theater, and people are just speaking politically in political correctness, and there is even not a glass ceiling. There is a cold steel ceiling against women. And as also a psychologist, I cannot perform as a human rights activist what I was trying from my 15 years old. And today's I just was searching for guideline. What should I do to be listened to defend rights of the vulnerable people and to defend myself, actually, because 6 weeks ago, I was domestically abused, and the police did very, very nasty thing. And even though I'm trying to defend myself, do you know what they said? They said me that in the police station, are you a lawyer? I said, no, I'm a psychologist. They said, you're acting like a lawyer. And I said that, okay, it is the thing, I can study because I'm graduated as top student from top universities. If it's the thing, yes, I really can study. So as one of my role models, I'm really trying to learn from you. What should I do to listen?
Well, thank you very much. That's a very wide-ranging subject, and I'm sorry that that you've had these experiences. I really am, but obviously I admire the support you're giving in human rights. I'd just like to say that psychology is important to legislation, which is our subject tonight, and behavioural science in particular has had a huge effect on legal thinking, and as it has in other fields, because it's expanded our horizon of thinking, the rationality and the reasoning. So apart from that, I don't think I can really answer your question in this forum.
Lady Arden, thank you very much indeed. Can we give our speaker a big round of applause? There are some drinks, I think, teas and coffees at least outside. Please join us.
Thank you for your kind.
Splendid. Well, thank you very much indeed. Tour de force. Tour de force.
Oh, that's true. Something I want to say.
Last one. Splendid.
There's always one.
That was great stuff. And I